All right, welcome everybody. Happy New Year. Thank you for being again with us today. Or if you are new, welcome. And today we are going to be talking about wills, probate, other planning documents to think about. And we have Allison and Melissa again with us. But before I do their introductions, first, I need to talk to you and remind you guys about Partner Resource Network. My name is Veronica Alvarez, and I work for Partner Resource Network. So Partner Resource Network is a parent training and information centers, PTI, for Texas. And we are funded by the Department of Education, specifically the Office of Special Education. And we provide free resources, and we help parents with children with disabilities and youth with disabilities that we call self-advocates. Our mission is to empower and support Texas families and individuals impacted with disability with special healthcare needs. We serve parents of children with disabilities and youth with disabilities from the ages from 0 to 26. And Partner Resource Network was first funded in 1986. And now we have 4 projects serving parents. I'm part of the team project in the red area you can see there. So I'm in Austin and surrounding areas in Region 13. We have also the Region 20, that is San Antonio, and then Region 1. Those 3 regions are part of the team project. But if you are out of the team project, we can, and you don't know your regional coordinator, I can help you with that and put you in contact with the coordinator near your area. We have 20 coordinators in all Texas, and we are part of the same family, and we are the parent training and information centers for Texas. Our services are free, and we offer parent workshops, youth workshops, webinars, information and referrals, one-on-one technical assistance. We do a lot of support in our meetings, or if you need some support in the IEP documents, we can do that. We do once a year a symposium. We offer parent leadership training and youth leadership trainings also. So for today, if you have any question, please use the chat box or the Q&A that you have there. Right now, your microphone and your video is off. So please type it, your questions, and Allison and myself, we are going to be monitoring that. This presentation is going to be recorded, so we are going to share with you guys in a later date in our Facebook pages, and also we are going to share with you a YouTube channel that Consolidated Planning Group have with all this presentation for you to have later on. After we finish this presentation, you are going to receive a survey link with an evaluation. Please help us. We really appreciate your feedback. And with that, we report to our grant, and we can continue to give you free resources and Partner Resource Network. That's how we work, right? Reporting with those evaluations. So for today, we also do not provide CEUs. We only do certificate of attendance. If you need one, please type it in the chat box and I can make one for you. And again, that's my contact information, my phone number, my email, and please visit our website, www.prntexas.org. We have a great information about disabilities, special education, fact sheets, a lot of information in our webpage. Also in the chat box is my contact information if you need it. So I'm going to stop my screen at this point, and I'm going to present our speakers for today. We have again Allison Chabert. She is a financial planner with a lot of experience working with families with special health needs, more than 25 years working with families. She also is a mom of special needs kids. And she is a financial planner, has a lot of experience talking about the topic of today. And also we have a special needs lawyer with us. We have Melissa Donovan. She is from Texas Trust Law. They have an office here in Austin, and she can talk more about their services. So thank you guys for being here with us today, talking about, are we prepared as parents, with the wills and those the documents that we need when our kids are older and stuff. Okay, so Allison.
So Melissa, if you want to go ahead and start sharing your screen now, that would be great. Welcome everyone, Allison Skalberg here. So again, Happy New Year. Welcome to the new year. And we have a whole bunch of awesome topics that we're going to be going over this year in our webinar series. So we're always glad to be back with you, Veronica. Consolidated Planning Group, we are a holistic special needs planning firm. Melissa and I have done presentations together in the past. And one of the regular comments that come up is, why do I need a special needs planner? Why do I need a special needs attorney? What are the differences? And, we've done a whole presentation on that. But in short, we're the money in the right buckets. And Melissa and, law professionals in the special needs community, they're the paper, they're the legal documents, they're the documents that have to happen. They're the guardianship, they're the wills, the trust, et cetera, et cetera. And so you need both of us, and we work closely together. But today's topic is a great topic. And from a financial planning perspective, what I would say is it's probably up there in the 90th percentile somewhere of the number of families that either do not have a will or have a will that is very, very outdated and needs to be updated, or families that have it on their list of things that they were going to do, but it kind of got put on the shelf on the back burner and it never got done. So if that's you, and if you've been beating yourself up about that, I just want to tell you in that 90th percentile, you are absolutely not alone. And we're really, really glad you're here, because these topics are super, super important. And in the world that we've been living in the last 2 years of a lot of uncertainty and untimely deaths and things like that, it is all the more important to get these things in order. What we also see is that people have crises in their life, and it prompts them to take care of these types of things. But the issue is sometimes it's too little, too late if a person has diminished capacity and can no longer sign. So these are all things to be visiting right now. So again, as Veronica said, we want you to put your questions in the chat box. I'm going to turn everything over to Melissa. We're going to be monitoring those questions and answering just as many as we can. And we will be finished today on or before 1 o'clock. So if you were wondering, that's for sure. All right, so Melissa, thanks for being back with us. We're glad you're here, and just turning it over to you.
Thank you both. Thanks for having me again. Always a pleasure. I think Allison's become one of my favorite people to do presentations with over the last year. It helps that she's so well acclimated to doing things on Zoom. But so what we're going to talk about today, in this first slide, this is just, we got to do it. So we're going to kind of go through here, but we're going to talk about what I generally refer to, and a lot of people generally refer to as estate planning. So we will talk about wills and powers of attorney and all of the different things that are just important to have in place. And as you may be able to tell from the questions on this slide, when you're saying, do you need a plan, and all of the potential things that might apply to you, long story short, everybody needs a plan. It doesn't matter if you are single, if you are married, if you have children, if you don't have children, if you have adult children, if you have young children, but especially if you have children with special needs, you absolutely need a plan, because we're going to walk through some information today. And just generally speaking, if somebody does not have a plan in place, newsflash, you do. You just don't probably know what the plan says, but the state of Texas does, and we're going to get to that in a minute. But what the law says will happen with your property can be disastrous if you have a child who has special needs. So we're going to kind of walk through those different things, what you can do, what might be good options, and just kind of generally how the system works. So like I said, everybody needs a plan. And to the point that Allison was making a few minutes ago, you are in good company if you do not have a plan. Last I checked, across the country, the statistic was somewhere in the 70s, 70%, where people just die without any kind of plan in place. And to what Allison was saying about being upwards of 90 if they have no plan or an outdated plan, in my experience, is probably pretty on the nose. So this is what I kind of talked about just a second ago. So people think that they don't have a plan if they don't have a written will in place. You do, but the legislature of the state of Texas has decided what your plan is. And as an attorney, these are things that, we have to be well aware of. And here in Texas, being a community property state, oftentimes there is a lot of confusion about, well, what does that mean? And especially if you are married, you might be very surprised where property goes if there's not a plan in place. So this information here kind of lays it out. Basically, there is some information further on in this presentation in regards to what is community property and what does all this stuff mean. But essentially, as a married couple in the state of Texas, property breaks down into two categories. It's either community property or it's what we know as separate property. Community property is most property. It's presumed community property if you're married, but it's essentially anything that you have accumulated during your marriage. And separate property is anything that you brought into the marriage. So if you had bank accounts or retirement accounts, or you owned a piece of real estate, you had a business prior to getting married, then you get married and there's no kind of prenuptial or postnuptial agreement in place, your property is going to be dictated by these laws. Now, if somebody passes away, this kind of gives you two examples of the breakdown. I didn't want to overwhelm y'all with every single possible permutation because we don't have 7 days probably, and you don't want to listen to me talk for 7 days, I am sure. But this gives you a little bit of an idea because a lot of couples think if I am married and I've got kids, then everything's going to go to my spouse anyway. So I don't need to worry about it until there's only one of us left. That is actually not accurate. So community property, what that means is if I have a bank account and my husband has a bank account, but those bank accounts were all completely opened and funded after we got married, it doesn't matter that my husband's name's on his account and my name is on my account. We each have a 50% interest in all of it. So community property, bank accounts, real estate, could be anything. All of that will go to your spouse. Basically what that's saying is that your spouse already owns 50%, and if you pass away, they're going to get your 50% of the community property as well. But anything that is separate property, in that first example where you've got husband and wife and all of the children are of that same marriage, the separate property is actually going to be shared with the children. And the interesting thing on separate property is that's going to be the case whether it is a blended family or not. And we have this interesting thing here with real estate of what is referred to in the law as a 1/3 life estate. This is kind of like something in real property that we learn about in law school called the rule against perpetuities. And it's a little bit of one of those things that is, nobody can really well explain it to you. But basically what a life estate in general means is that you have the right to use the property and benefit from the property, but you can't give it away. It's not yours to freely sell. So if, let's say, you have adult children and there's a piece of real estate, you have to get all your children to agree that that property is going to be sold. Or if there's a bank account, so real estate, personal property is anything outside of real estate. So bank accounts, anything business related, if you own an LLC or anything like that, just think personal property, not real estate, okay? Now it gets even more complicated and can be quite surprising for some people if it is a blended family. Because in a blended family, the community property doesn't go to the spouse, it goes to the kids. And I've been in that very awkward scenario where a couple of years ago, these are always those situations where you hate to have to be the one sitting in front of a client and telling them kind of the bad news, essentially. But I had a sweet lady come into the office a few years ago, and her and her husband had been married for years and years and years. She was probably in her upper 70s, lower 80s. They never had children. And just a few years before her husband had passed away, there was a daughter that came out of the woodwork that they had never known. It was, you know, high school relationship that he was never told about, but she was his daughter. And he never did a will, and he passed away. And I had to tell this sweet woman that she now owned her house, one half with this girl, that they never knew. And they didn't really know until a few months before he had passed away. So those are the scenarios that if you have no plan in place, you more likely than not are going to be very surprised. Well, you're not going to be surprised because now you know. But now that you know, it's a good idea that you probably want to counteract that a little bit. And that's the idea of having a plan in place, is that essentially what you're doing is you're saying, I want to write my own rules. And that's what you do when you have a will or when you do a trust and you do a power of attorney. It's you saying, I know there are rules written, but I want to have my own rules for what I own. I want to control what I have.
Alisa,
So-
we have a question. Yes, Alisa?
Mhm.
Yeah, so when you're referring to a blended family, you're basically meaning stepchildren or families where there might be his, hers, and our children, is
Correct.
basically what you're speaking of. We do have something else in the chat box where someone said that we've done a trust and a will, but we didn't include the child as special that has special needs. Do we need to mention them now? What are the advantages or disadvantages? You may be addressing that later in your presentation, so you can reserve the right to defer that. But how do you want to talk about that now or in a few minutes?
So I'm happy to answer that question now. So no matter what kind of planning you have, and we're going to get into, you know, wills and trusts and why you might have one versus the other, or why you might have both. And you actually would have both if you have a trust. It's just a little bit of a different kind of will. But to the point of your question, if you have a special needs child that is, you are fairly certain is going to need benefits, or you are even thinking about it, and there's not provisions built into the existing trust or will to provide for the protection of that, then yes, it is incredibly important that you make amendments. And you can, depending upon, I don't want to make assumptions here, but if a trust is what's known as a revocable trust, a revocable or a living trust, that means you can change it so long as you have the capacity to do so. It's always a good idea to amend that and rework it over time as your situation changes. And it sounds like maybe when you had done it, it wasn't a situation that you had been aware of, particularly at the time. Now there's been a change in circumstances. So now it's a good idea to, you know, work with your attorney, go back and look at what may or may not need to be done. For example, every single thing that we do in our office, because this is a concern that we have for anybody, whether it's a situation they know of right now or one that could just pop up unexpectedly in the future, everything we do has a contingent special needs trust in it. Most attorneys I know who do have at all a specialty in special needs or estate planning, they do things like that because you think through and you know, okay, this might be an issue. So we're going to include some, at least minimal provisions for it. But if you don't have some kind of special needs or a fully discretionary trust, and I know that those words might not mean a whole lot to a lot of you, we'll kind of get into that a little bit later. But if you just have, let's say, outright distributions to kids, that could be disastrous for someone on benefits, because as soon as they inherit that money, if that child, let's say, is 22 years old now or 30 years old now, and they are on Medicaid or they are receiving SSI, and they inherit even $15,000, $20,000 outright in their own name, it's going to cost them their benefits, even if just for a minimal time. So it's really important if you do have a child that does have special needs and there is that concern that we may need benefits, we're going to want to make sure that that's planned for. And again, you can do that within a trust, you can do that within a will, but it's really important that you look at amending things over time. And I tell all of my clients too, just as a little bit of an aside, you can do the best estate planning in the world. You don't want to ever put it on a shelf and forget that it exists. Again, kind of going back to Allison's point earlier, people have outdated stuff. And that could be for many reasons. It could be that, there have been so many legal changes that it's just not as effective and efficient as it may be if you had newer things. And it may be that in this situation, your personal situation has changed and you need to adjust for it. So usually I tell clients, no less than every 5 years, pull out, the estate planning documents, take a look at it and just see what you've got going on. And are you still in a place looking at those documents where you feel like you need to be? And if not, then you need to reach back out to your attorney and look at making some adjustments.
So I do have another question I'm going to read to you. Can a will be obtained, created to ensure if a biological parent of a special needs child dies, the step parent who has been present and very active in their stepchild's life will be identified as the child's decision maker? Hold on, I'm still reading here. For medical, academics, and other factors like that. So in the example, it's not a custodial parent, but maybe, or a bio parent, but it's a step parent. How does that work?
Yeah, so this would fall under, generally speaking, a declaration of guardian, depending upon the circumstances. If it's a child who is a minor or a child with special needs who is in a situation where they would need an actual guardian appointed, there's kind of 2 points to make here. You can always do a declaration of guardian saying, this is who I want to be making decisions for my child. Where there is another legal parent involved, that in and of itself doesn't give you the right, or anyone the right, to take that other parent's right to do those things away from them. I actually run into this question a lot with clients, and I completely understand. And this is what you can and this is what you cannot do. You can tell the court, my preference is that my current spouse is the guardian. And if the biological parent, the legal parent is not, they don't want to argue with that, or if the rights have been taken away from that person completely, then that's probably going to stand with the court. But there's no guarantee on that. And that, again, just goes back to general, it's more family law issues. You can't really take away the other parent's rights. However, what you can do is you can say, and this is also something that we get a lot in situations of divorce or whatnot, you don't want that other, that ex managing the money that you are leaving for your child. So while you may not have control over who the guardian for your child will be, if there's another legal parent, you can control who's going to be the trustee of the trust for your child. So maybe the step parent will be the trustee of a special needs trust, or whatever kind of trust is necessary for that particular child.
So in regard, to getting something set up, we've got something in the chat box that says, if we don't have one now, where can we start? Is there a template online before we can meet with an attorney? And I would just like to start by saying, in my professional opinion, I am not a fan of DIY wills and downloading templates. You don't know that they're even state specific. You don't know how old they are. And you could run into some snags with that. And what I would say is, if you're attending this webinar today and you do indeed have a special needs child, I always, and coming to you as a parent with special needs kids, our situation is specialized. Okay, this is not a do-it-yourself project, or let me save a nickel on this. Like, there's a lot of places that we can save money, and there's other things that we can be really smart about. But I think that these matters are far, far, far too important to take a chance with amateurs or inaccurate documents. So really, we recommend, working, with a specific attorney on this. And if you do have a special needs child, I really do, tend to make referrals to attorneys that are nuanced in special needs and have some knowledge in that, because from our perspective, and this is no offense to Melissa or anybody, all attorneys aren't created equally, just like advisors. All advisors aren't created equally. Some are nuanced and special needs and many are not. So I'm going to turn that over to you, Melissa, but that is where we see a lot of documents that are just plain wrong, that they need to be corrected because of online templates or just, maybe somebody that was kind of dabbling in estate planning as opposed to really being, specialized in that. So can you address that, Melissa?
Yeah, well, and I will say, I'm glad that you kind of prefaced, because I know it always sounds a little bit biased from the attorney saying, I don't recommend going to an online source for a will. But here's what I will say about this. Can you probably go online and pull some template? Yes, it's a can or should. Can I? Yes. Should I? Not in this scenario. Are there emergency situations where maybe that's a situation that you might get involved in? Even in that scenario, we still don't recommend it. It would be better. You'll see on the slide in front of you, that very last line talks about something called a holographic will. And there are some situations where even with clients who have reached out to us, it is such an emergency and there's no opportunity. If, let's say, someone is on their dying deathbed, they're in the hospital, there's no way they can get everything accomplished with an attorney. That's kind of the purpose behind why holographic wills are still legal. Basically what that means, holographic will, is it's just a will that is completely written in the handwriting of the testator. Just means the person writing the will, whose property is being handled through it, written and signed by them. Is it perfect? No. Is it sometimes, more often than not, better than having nothing? Yes. In my experience, it is also better having a holographic will than having anything pulled from online, whether it's something you just Googled and found through an image search or went to any of the numerous online websites. We won't name them, but it is always best when you have specific scenarios. When you have a special needs child, in my mind, there is no difference between a client who walks into my office and has a taxable estate and their need for customized planning, and a client who walks into my office who doesn't have a taxable estate, who maybe has a few $100,000 but has a special needs child. Those things are just as important to my clients. So it's really important when you have really important issues that need to be dealt with and that you need to protect benefits, that you are working with an attorney who knows what they're doing. Because even in my experience, to what Allison was saying, I've had plenty of clients walk into my office with wills done by attorneys who, whether they were, the criminal lawyer who's dabbling, because you may have heard them say it, anybody who graduates law school can do a will. And again, can versus should is always an important distinction. But we see a lot of stuff that comes through our office that, was pulled online or was done by another attorney that is still not accurate and is still going to be problematic for benefits. So I can get kind of wordy sometimes. I'm a talker, but long story short, it is not a good idea to be pulling things offline when you have a specialized situation, like I'm expecting probably most of you on this webinar today do have. Having a will in place, you can kind of see here, the actual legal requirements for a will, they're relatively straightforward. You have to be over 18 unless you meet some of these other qualifications. It has to be in writing. It does have to be witnessed. It doesn't actually have to be notarized. You have to have two witnesses, but you'll notice there's a point there I make something called a self-proving affidavit, which is something that we do as attorneys, because if you have a will that's not done with a self-proving affidavit, you've done a will, you've signed it, you've got your two witnesses who have witnessed you signing it, and then you pass away, those witnesses have to be pulled into court when you pass away, what we call the probate process, to prove who you were, that you had capacity. Capacity just means that you knew what you were doing at the time. You understood, what you were doing, what your estate looked like, who your closest family members were. Testamentary capacity is actually one of the lowest bars for capacity when signing legal documents. So the thing with a self-proving affidavit is that by having that attached with your will, it's a second step whereby the witnesses, the testator and the notary are also saying, we are certifying that this was done with a testator who has capacity. Everything was done correctly. It was your final true wishes. So nobody has to go to court except for the executor. And even when I say the executor, it doesn't technically have to be the executor, but it really does simplify the actual process of probate when things are done. And those are things that, the way I like to explain it is, you hire an attorney to do a lot of things, particularly with estate planning. We are not document creators, we're counselors and advisors. So a client doesn't come in and sit in my office just to have me pull out a document, put their name on it, and have them sign it. A client comes in and sits down in my office so that we can talk through your individual circumstances and what your concerns are, and how do you properly address that within the planning. That's something you're never going to be able to do with a Googled document, because Google's not going to give you that advice. That's the difference between working with an attorney who's helping you out and just pulling something online. You're not going to be able to get that advice and actually make sure you're doing what's in your best interest and what's in your children's best interest.
So can we address, this is in the chat box, and the question is what is the exact verbiage to give entities to use for a beneficiary who is a special needs child with provisions for a special needs trust at our passing? And I think that this is a good point to talk about not naming specifically your special needs child outright. Do you want to address that?
Yeah, so you are not going to name your special needs child outright ever. If there's a situation where they're going to be needing benefits, then you're not going to be naming them outright. You're not going to be naming them by name. Now, I do have to say, this is something that you really probably should talk to your attorney about any specifics, because it does kind of depend upon how documents were drafted. But generally speaking, if you have a plan in place that has a trust for a special needs child, you're going to be using some permutation of the trustee of the trust created for that child in your trust, in your will, or if there's what we generally refer to as a standalone or an inter vivo special needs trust, then you would be naming the trustee of that trust. It really depends on your individual planning. And that's something that when you're working with an attorney, they really should be giving you that guidance and that language with your planning. It's something that we do with all of our clients. You have a plan and we give you an entire letter saying, okay, now this is how you designate your beneficiaries. You do it this percentage to, this trustee if you've got multiple children, and this percentage to that trustee. That's how that would work. Now, this slide here just goes through different types of probate here in Texas. Now, this, I'm not going to spend too much time talking through this, but there are some specific situations that I do like to just go over, because these are some things that I will run across a few times. A lot of the times what I see happen is when I will have a client come and meet with me who is looking to do their own planning. And more often than not, this occurs with spouses. I've had it happen with children where, someone passed away years ago and they've been told, oh, well, it was just the house and someone told me that it's mine, so I never did anything. Property doesn't automatically transfer from one person to another just because there's a will in place that says so, or under the law, you're the only heir. There's always something that has to be done. So either if it's an account, it has to have a right of survivorship or a beneficiary designation, or if there's none of those things, let's say it's a piece of real estate, one of these things is going to occur. So affidavits of heirship are probably one of the most simple forms of probate, that along with small estate affidavits. And these are things that can be really helpful if it is a very small estate or we're just dealing with maybe one asset. Affidavits of heirship are only used with real estate. There are pros and cons to everything. I'm not going to get into too much of all of that because we could probably have a whole nother conversation on all of that. But the biggest takeaway that I always want people to have when looking at, okay, I've got a will in place, is knowing just because you have a will in place does not mean that nothing has to occur when you pass away. I get that a lot. I have people, they walk into my office, we sit down and they go, okay, I need to avoid probate, I need a will. A will does not avoid probate. There are other ways to avoid probate, but if you have a will and nothing else, that means that when you pass away, someone's going to have to probate that will in one of these ways. Now, they might be able to do it more simply with something like a muniment of title, or they might have to go through, I usually refer to it as a full probate. And that's what most people think of when they think of probate. You have to go in, go to a hearing in front of the judge, and the judge is going to say, okay, this is a valid will, this person's passed away, yes, you're qualified. And if you have a good will in place with everything that needs to be in there, they're going to say, go ahead and do what you got to do. And hopefully they're not going to have to go back to court again. Now, in terms of avoiding probate, these are some of the ways that you do. So rights of survivorship. If I've got a bank account with someone, does it have a right of survivorship? This is also something to look at because, again, going back to the community property things that we talked about earlier, a lot of couples think that, well, if we've got a joint account, that means if my spouse dies, it's just mine. That is a very, very rare thing in Texas because of the way community property laws work, and rights of survivorship on bank accounts actually require very specific language. So if that's something that you're wanting to look at, it's something I advise clients to make sure you're checking with your bank to see if you have it. POD, TOD, that just means payable on death or transfer on death. It's basically the equivalency of having a beneficiary designation. It's just we use different terms for different types of accounts. Those would be anything like you have on a bank account, a retirement account, a life insurance policy, an annuity. And whenever you have things like rights of survivorship or POD, TOD, beneficiary designations, those are always what we refer to as professionals. We refer to them as non-probate assets. The reason we refer to them as that is because those designations are going to override any planning that you do. So this can also get people in trouble. So let's say we do have a special needs child, and let's say it's not a child in the way most people think of it. You know, it's not a minor, it's an adult. And I've got a client who walks in, you know, maybe she's in her 60s or 70s, and she just added her daughter, who is also on SSI and Medicaid, as a POD beneficiary on her bank account. Well, she did that because she didn't want to have to go to probate. She was trying to save her daughter money. Okay. We don't have to go through all the process. But by doing that, it's overriding any potential. Let's say she did have a trust built into her will. It's not going to go into the trust for her daughter in her will. It is automatically her daughter's the moment she passes away. So what does that mean? That money is now, again, potentially going to disqualify benefits. So we have to be really, really careful on things like this. And to be quite frank with you, it's why when I'm working with clients who do have special needs children, we are really not strong proponents of things like right of survivorship or POD or TOD. Beneficiary designations done properly on retirement accounts and life insurance policies, those are a necessity, but I'm not a big fan of POD and TOD on bank accounts, particularly in that scenario, because you need things to be able to go through the trust, the will, to make sure it actually gets into the trust that you are creating for your child.
So basically, in this example, you're suggesting that the payable on death or the transfer on death would be payable on death to the trust, not to an individual, and then the trust would distribute the assets in the way it's supposed to.
Right.
Okay, that makes sense. And one thing that you mentioned that I wanted to ask about on this transfer on death or payable on death, let's say we've got a husband and wife joint checking account. They've got a payable on death of another family member, not special needs. So one person dies, the other spouse is still living. In that example, it wouldn't go payable on death to the beneficiary, or would it be 50% of it would?
It's possible it could. It really depends on how the bank's contract is. Because if it is, which can happen, if it's a joint right of survivorship account that then also has a payable or transfer on death, then it's going to stay with the spouse, and only on the second death does it go to that transfer on death beneficiary. But it can happen where the account between the husband and wife is not a right of survivorship account, in which case, if they've done that TOD, you have to look very, very carefully at what you're signing, because I've seen it happen where clients have signed a form thinking that that's exactly what they were doing. It stays with my spouse, and then it goes to, my daughter, my son, when we've both passed away, and that's not what they signed. So
yeah, that is such a good point to bring up, and something that people don't normally like sit around and think about. So that's really good. And then one thing that I just wanted to reiterate that we see and hear as a constant issue is that there is a misnomer out there in the general public and population that whatever you say in your will goes. And so that's what you were just hitting on, that's true for a lot of things, but it is not true for 401ks, 403bs, pensions, life insurance, annuities, checking accounts. It's the beneficiary. Whoever the beneficiary is who's getting the money. And if it's an ex-spouse because you forgot to change your beneficiary, or someone you now really despise, or whatever, how that is set up is basically who gets the money. And then, of course, it can be, it can be disputed and hung up in court and for years if that can happen. We've definitely seen that. But understanding that those beneficiaries truly, truly do matter, in addition to your will and your trust documents, it is so super important to know that. And another thing that is also important to know is that life insurance proceeds pass tax-free to heirs, right? And that's for individual human beings. A trust is not a human being. So when we change life insurance beneficiaries to trust, and it's not something that we don't do. I mean, a lot of special needs families have their beneficiary of their life insurance as the trust, because that's what's going to fund the future care for their child, but it can change the taxation of those benefits or lack thereof. So
it depends on the type of trust, though. It truly depends on the type of trust. It can go into a trust, and that's why you'll often see attorneys recommend, like if you have a joint revocable trust or you have a revocable trust going to the kids, you will see attorneys recommend getting into the trust. And that is also where good drafting becomes really, really important. That's something I hear a lot, not on the life insurance side of things, but I've heard people, I talked to another attorney and they said I shouldn't do a revocable trust because I'll lose my homestead. Those are the types of things where when people are very, very involved in this area of the law, like people like myself, who it's all I do, I don't do anything else. We are, I hope no one takes offense to me calling myself this, but we're dorks. We spend all of our, as my boss likes to call it, free time, looking at ways that we can do things and how can you improve things. So just be careful when it's kind of like the Google stuff, learning information where you're not talking to someone like Allison who really knows what she's talking about, or someone, you just need to be careful that you're not being scared off from something that is not accurate at that time, or that there's a way around it, essentially. The other thing I did want to point out on here, because this is something I get a question on a lot, because it's kind of the new, it's maybe not to the rest of the world, but the new hot thing in the estate planning world here in Texas, transfer on death deeds. So transfer on death deeds, for a lot of people, we do these all the time. There are benefits and there are cons, just like with most things in life. But the idea with a transfer on death deed is you're able, or a ladybird deed, you are able to provide that your house is going to go to a specific individual or individuals the moment you pass away. So it's another way to avoid probate on the house. So there's many times where I'll have a client who maybe has a house and a relatively simplified structure of their estate, where maybe they've got their retirement account that's going to be beneficiary designated, and a life insurance that's going to be beneficiary designated. And if there's no special needs concerns or anything like that, this may be a good option to look at. Think of it like creating that beneficiary designation for your home. And I did notice there was a question here about, having things redone if we go state to state. There are a lot of general informational pieces that are going to apply across the board. It doesn't matter where you live, you need to have a plan in place. But to that point, a lot of things are very state specific. I tell my own clients, if you're going to move to another state, it's a good idea to have your plan looked at by an attorney in that state, because there may be some things that need to be adjusted. There may not. There are some things that are very state specific. Like we call it magic language here in Texas, which helps to simplify that estate planning, that probate process. So we have things like independent executors. So if you have a will that was done, in this example, the person said Arkansas, so I'll pick on Arkansas for a second. Let's say someone was moving from Arkansas to Texas. They may not have all of the things in their wills in Arkansas that are necessary for that very simplified probate process here in Texas. And vice versa. There might be some things in the Arkansas laws that a power of attorney should have in the documentation, or a medical power of attorney looks very different. Or there might be magic language in Arkansas for a will. So it's always a good idea to have things looked at. The other side of that is, particularly with special needs, while Social Security is pretty much across the board, Medicaid, again, a lot of this stuff is very similar, but there are little intricacies that can really make a difference in terms of the flexibility of the planning and what one state's Medicaid office might be okay with versus another state's. So it's always a good idea that you have, your plan looked at, whether you're moving to a new place or not. Now,
as it relates to guardianship, though, the guardianship is by county. So definitely, if you have guardianship of the person and you move even counties within Texas, that does need to be addressed. Is that correct?
Yeah, you have to essentially recertify in the new county. You're having the guardianship moved. It's a much more simplified process than actually the first obtaining of the guardianship, but it is important that that gets done. And I've had clients who have taken a little while to do it, but you need to make sure that you're getting that accomplished if you move.
I have one other question as it relates to that. I know we're not on guardianship, but I know that that's a topic that's near and dear to everybody's hearts if they have a loved one that needs care forever. Is if we have a loved one that is in a residential placement that is outside of our county or outside of our state, again, in that example, if the special needs loved one is living in the other place, does the guardianship need to be of that county?
It would depend on how permanent the move is.
Okay.
So if it's something where someone's going to be, moving to a completely different area of the state, and they're going to be there for several years, or the idea is that this is going to be a new permanent place for them to live, technically the jurisdiction is where the guardian is. That's the primary point. Jurisdiction just means what court has the authority to dictate what happens with that person. And the primary point of jurisdiction is where does the person who needs the guardianship reside? So if they are residing in Tarrant County and I got a guardianship in Travis County and they're residing there long term, it really should be adjusted over to Tarrant.
And one question on that, do you need an attorney to move a guardianship to a different county, or can you just file that with the clerk's office? How does that work?
So you can attempt to do it on your own. It depends on the circumstances. If it's something that people feel like they are equipped to do, let's put it that way. When you're applying for guardianship, you need an attorney there, but especially if you're dealing with guardianship of the estate, just because of the way that laws work in terms of you can't represent yourself trying to represent someone else if you are not an attorney. I know that might sound a little convoluted, but it's the same reason an executor probating a will with a hearing cannot do it without an attorney. There's no pro se probate for truly having, if there's a hearing required. But if you're moving and it's a guardian of the person, it is something, technically speaking, you don't have to have an attorney to do.
Thank you.
You're welcome. Now, I know we're kind of running short on time here. So the last kind of point on that avoiding probate, and I know I've had a couple of people ask these questions throughout, is the issue of a trust. So when we're talking about estate planning, this kind of gives you some information on, what is a trust and what are we talking about? At a very base level, a trust is a contract. And there's 3 roles in any trust, and you have what's called your grantor, and different attorneys will use different terms. Sometimes you'll see trust maker, sometimes you'll see settler. They all essentially mean the same thing. It's whoever is taking their property and giving it. So you'll notice how this is kind of worded here so that you can kind of flow through it. So the grantor is giving their property to a trustee who is going to manage that property for a beneficiary. Now, this is where we get this phrase bundle of sticks. And this is something that probably every property law professor across the country talks about first week of property law, your first year in law school. And it's because it's a little bit, property ownership is more complicated than just saying I own it. It's about what is your ownership interest in it. And that's kind of what a trust does, is it breaks apart the different ownership issues to 3 roles. And the reason that we do that is twofold. The biggest reason for most people is avoiding probate. The other side of things is just to have one umbrella that people can easily manage assets under. And there's a plethora of, smaller reasons in between. Inter vivos versus testamentary just means, when are we creating the trust? Is the trust being created during my lifetime, inter vivos, or living, or is it being created only upon my death, testamentary? So maybe I have a testamentary trust for my child that's set up in my will. It doesn't exist during my lifetime, but as soon as I pass away, any money that would be for that child is going to go into a trust. And let's say that child is 12. We're not going to hand a 12-year-old outright a bunch of money. That would be, well, might not want to hand a 20-year-old a bunch of money outright in many situations. So you're going to have a responsible older adult that you believe can more responsibly manage that money for the benefit of that person. The issue of revocable versus irrevocable trusts are used for main reasons. Asset protection as a big umbrella, but within that umbrella of asset protection, we can talk about things like asset protection in the way people think of it. Like if I get into a car accident, someone's not going to be able to take that property from me, but it can also be asset protection in terms of Medicaid estate recovery. It could be asset protection in terms of special needs trusts, where we're just putting money for another person into a trust now so that they're not going to lose benefits, but somebody can still allot gifts and provide for that person above and beyond what Medicaid or Social Security would cover. Both of these are going to avoid probate, but they're done for very, very different reasons. Living trusts are more often than not what we're talking about when we're talking about, okay, a will versus a trust, and what are we doing here? Revocable trusts, they are inter vivos trusts. They're created during your lifetime. In this situation, we're not looking for asset protection. We're just looking for things to be more easily managed. What we will talk about a lot here is it's a lot about control. The more control that someone wants to have over what they own, they may gear more towards having a trust in place because it allows them to have that higher level of control over things. The way I like to explain it for clients is, think of a trust document like an instruction manual. It's the grantors, the person putting the money into that trust, telling whoever is going to need to manage that money, not just that they can manage it, which is what a statutory power of attorney would do, but how they should manage it. How do they want to be taken care of if they're incapacitated? Who are the other people in their life that they need to make sure are taken care of? Spouses, children. Maybe we take care of an elderly parent or a disabled sibling. Those are all things that if you have the trust in place and you become incapacitated, you have those provisions built in for a person saying, these are the people I want you to be able to take care of. And then also, it will distribute the assets at your death. So in that situation, the way that we avoid probate is because when my property is not in my name, but my property is inside this trust or this entity that I have been managing, then if I die, the actual owner of the property, the trustee of the trust, whoever that may be at that time, has not died. So nobody has to go to probate to take my name off of my stuff because my name is not on it. That's really all that probate is. Probate is just the process of taking a dead person's name off of an asset to put a living person's name on it. And that's why you avoid that with a trust, because you're not putting your name on your assets anymore. You're putting them into this entity, and you're designating, kind of like if you had a company, you're designating your lineup. You've got your VP, you've got your CEOs, you've got all of the people behind you that can step into that role of management if something happens and you pass away, you're incapacitated or whatnot. Things that the trust can provide: yes, tax planning, asset protection planning for spouses and children, and for a lot of my particular clients, the biggest thing is special needs planning. And you can provide for that in multiple ways. In terms of this, a living trust, one thing that I do like to say, doesn't necessarily need to be a living trust in the sense that it's a revocable trust that, me and my spouse make together and it's for us. You can do a third party, what's called a third party special needs trust here. And that trust is actually for your child, but it's still revocable so that you can still make adjustments to it. Or you can do a third party special needs trust that you don't have the right to make adjustments to, an irrevocable trust. So there's a whole spectrum of how trusts can be done. In terms of different reasons why people might want them, this kind of lays out with my clients what I have tended to see. This kind of goes through who in my experience more often than not will want to have a trust as opposed to having a will in place. For blended families, I always kind of talk about the Brady Bunch scenario. Very, very prevalent with my clients who are in that scenario, because we want to be able to make sure that both sets of kids are taken care of, but we still want to make sure our spouse is taken care of. So a trust provides very easy ways to do that. The other thing you'll notice here is contentious family situations. Is there someone that's being disinherited? Is there someone that you are concerned about contesting a will? The reason that trusts become really beneficial in that scenario is who can actually contest things. A will can be contested by any of your heirs, meaning anybody under the law who would potentially have a right to inherit through you. A trust really can only be contested by the people who are the beneficiaries of it. So if somebody is not a beneficiary of that trust and you're really, really concerned that they might try to kind of bleed the money dry during a contesting of a probate, that might lend itself to more trust planning, especially Medicaid planning, special needs planning, asset protection planning, tax planning, things like that. I did notice, I don't know if I caught it ahead of you, Allison, but I noticed the cost question, which I was wondering when someone was going to ask that question. But here's what I can tell you. A trust with most attorneys, yes, it is going to cost more to set up than having a will-based plan. I can't really give you an exact cost because every situation is different. Every attorney is different. And I know we've got people all across the state. So as I'm sure everybody can appreciate, what one might pay in Laredo is different than Dallas, is different than Austin, is different than any other place. So generally speaking, you could be looking, I can tell you what you'd be looking at in the Austin area, because that's where I am. In terms of working with an attorney that specializes in this stuff, if you're doing trust planning with an attorney who's taking care of the entire estate plan, you could be looking anywhere from $5,000, $10,000 upwards, $1,000. It just kind of depends. That's not everybody. It depends on the very specific scenario and what kind of planning is needing to be done, what their assets look like. Are we having to do tax planning? Are you having to do special needs planning? I know nobody likes getting that answer from me when I have to give it, but unfortunately, it's very hard to give actual direct costs because every situation is very, very different for people. I don't know if you want to touch on that at all, Allison.
No, I think that that's valid. I mean, I think on the low end, we've probably seen trusts in the 3,500 range. And I mean, it just depends. How many trusts do you need? What are we looking at? Is this a blended family situation? Is this a single parent? You know, when there's less complexity, it's less money. Yeah. That's all there is to it. So I think it is a wide range. It depends on the firms. And then, also I would also say that, again, in a specialized situation, you're getting kind of the care and attention that is necessary towards special needs and money in the right buckets and maintaining eligibility for those critical benefits that we were mentioning. So I know that we're running out of time. It's 12:59. So I'm going to let you roll with that.
So the one last thing that I will say, there are some things we didn't get a whole lot of time to talk about, which is probably okay. These are probably the things that are a little bit more common with people understanding: financial powers of attorney, medical powers of attorney, living wills known as directive to physicians. These are all really important things for everyone to have. And that doesn't just mean you, but if, let's say, you do have 18-year-old children who maybe are not dealing with any kind of special needs scenario or do not need a guardianship, it's really important that they have these things so that you can still help them. If you're the parent, you really want to make sure that they have those things as well as yourself, so that people know who's going to make the medical decision if I can't, who's going to be able to help me manage my money. So these kind of littler things are really important to have as well. And I know, as per usual with myself and Allison, we are talkers. We're pretty much out of time at this point, but I will just say I really appreciate y'all having me on again. I always enjoy being here. And if anybody does have questions and they would like to, I put my contact information in the chat box earlier.
And
so
I advanced the slides. I think the slides have our contact information. Yeah, I think we're good right there. And so thank you, Melissa. I think the biggest takeaway, you brought up some topics that I know that are just not brought up on a pretty regular basis. So I hope that that's food for thought for everybody. And wherever you are in the planning process, again, it's not about looking back, it's about looking forward. And you are here today, so we're glad you are. And so if it is something that you've kind of put on the shelf of what you're going to do, brand new year, it's a great time to get started and kind of initiate that process. We'll have more webinars with Melissa Donovan. We'll go deeper and wider on all other topics such as guardianship. We go deep and wide on all types of things. And the thing is each of these topics could be their own webinar for an hour, and because there's so much information with that. So thanks, everyone. Thank you, Veronica, again for having us, and we hope everybody has a great afternoon.
Thank you so much. And I saw a question that asking for the handouts. Yes, I'm going to send an email with all the information about the important topics that Melissa and Allison talked to us about. Thank you so much. See you in the next one.
Take care. Bye now.
Bye.